All who have business before this court, draw near, give attention, and you shall be heard. God save these United States, the great state of Florida, and this honorable court.
Be seated. This is not the largest audience ever watched arguments before the First District Court of Appeal. I think we've had 1,500 people in Orlando, in a hotel ballroom where workers' compensation cases. That's crowd. We certainly hope that for the students who are, we know how busy you are, that you're giving your time to be here. We certainly hope our time is instructive. And I'll say, as we said yesterday, some of you over there, we hope that someone will be very fine law students at this very fine institution will consider and explain about your career as a law firm if you want to be one of the 5 district courts of appeal. It's a wonderful learning experience. It's like a sort of general exposure. And don't take my word for it, just listen to the cases that you're going to hear argued today. And I think you'll see what first case on our docket is a case involving Florida's public records and open meetings law, the Sunshine Law. It's Grapski versus City of Alachua.
May it please the court, I'm Joe Lowell. I represent the plaintiffs' appellates in this case. We adhere to all the points in our brief and would reserve 4 minutes for rebuttal. We have 4 vital Sunshine Law issues before the court. First, did Alachua's specific consent agenda practice by which it approved the canvassing board minutes and 5 other items violate the open meetings law requirement that public decisions be taken in, quote, a public meeting open to the public, unquote. Second, does the fact that appellants obtained a copy of the canvassing board minutes before this action was filed defeat their right to obtain a declaratory judgment condemning Alachua's refusal to permit citizens to examine public records until they have been approved by the Alachua City Commission? Third, do the Sunshine Laws entitle or require Alachua to meet with the appellants to permit them to inspect public records, or may Alachua avoid the laws by closing and locking its doors to them? And fourth, are the appellants entitled to declaratory and injunctive relief to remedy Alachua's refusal to provide a written statutory citation to its claim of authority not to permit appellants to inspect public records? As to the open meetings question, this is what happened. Alachua published an agenda listing several items on what are referred to as a consent agenda. This included the canvassing board minutes. Alachua denied the appellants' repeated requests to inspect the canvassing board minutes prior to the public record, saying to them, you can't see them until after they have been approved by the City Commission.
Or if they had acquiesced to that request, would your public meetings claim go away? Is that the whole point there, that they did not disclose the minutes before?
That is a part of the whole point. And let me finish what I've got to say here, Judge Benton, and I think you'll understand, I know you'll understand, the whole point. The whole point is that the City Commission then permitted the public to come into the room, convene the meeting, but it denied the appellants or anyone else the right to inquire about this specific matter and 5 others. It denied any public comment or questioning about them. The Commission itself refused to say anything about them.
Or so the public meetings law is violated whenever a body refuses to hear a citizen who appears at the meeting.
Your Honor, that's not our position. And I'm going to tell you exactly what our position is. Now, I just want to set the stage here for you. The City Commission then approved those matters with a unrecorded voice vote and then, so far as they're concerned, adjourn. And the public was left without any knowledge whatsoever as to what the city did. Now, my question is, was this particular action taken in a, quote, public meeting open to the public? This court, or the court below, held that the law was not violated because it found no case law prohibiting the consent agenda. And it found, and it says the law imposes no requirement upon Alachua to publish an agenda. Now, this answer of the court ignores the point of the lawsuit, which is that despite the fact that the members of the public were present in the room, Alachua hid the content of what they were doing from the public. Now, as to the, quote, public meeting, unquote, aspect of a, quote, public meeting open to the public, this court in Ray has already held that the mere fact that the meeting room is open and people can come in does not satisfy the public meeting requirement. This court held that there must be physical proximity between the party taking the action and the constituency in which the action is being taken. Now, the Supreme Court has acknowledged these primary goals, and this is important to the public meetings laws: to promote public awareness and knowledge of governmental actions in order to ensure that the governmental officials are accountable to the people.
May I ask you a question, Professor Little?
Yes.
This goes, I sort of think maybe I see it the way Judge Benton's question went, although we hadn't really talked about that, which is that this then sort of flows from the failure to provide you the request, and then you couldn't participate. Arguably, you couldn't have participated effectively in the meeting without knowing what was going to be taken up on the consent agenda. But if your argument on, I guess your last point of your appeal has to do with the transaction of business under a consent agenda or action item, call it in the city. How would you have a court fashion a rule that would tell local government officials when they may permissibly use a consent agenda and when they may not? Because it's my understanding, certainly the appellees point this out, that consent agendas are common practice in local legislative bodies.
Your Honor, the point we're attempting to establish here is that a public meeting is not an open meeting if the action is taken in a way that hides the content of what's going on from the public. As to how to achieve what you're suggesting, I think the answer is simple. In this case, it would have been, does any member of the public wish to address any of these items?
But wouldn't that holding apply to every other city?
It absolutely would, and it should, Your Honor.
You do acknowledge, I'm not sure you acknowledge, but there doesn't seem to be any powerful authority that says that a city or county commission, city commission, county commission, school board must entertain questions from the public on every item that comes before the body.
Your Honor, I don't want to go that far. I think maybe we could. I don't want to go that far. Our argument is you can't hide things. You can't hide things from the public. And that's why this case raises a very specific issue as to how things were done here. Let's talk about this openness requirement. Public meetings open to the public, to the public. The Constitution requires decisions to be made in the open. That's what the Constitution requires. What does open mean?
Doesn't the case law suggest that even a violation of the the open meetings law may be cured by a subsequent open meeting that ratifies the previous action?
Absolutely does, but there's been no such curing.
Well, I understand in this case there hasn't. In this case there hasn't, but that holding, or those holdings actually, would seem to go along, make a fairly big crease in your argument, because the courts have almost seemed to acknowledge that if local government bodies violate Florida's open meeting laws, they can always cure those violations by coming after a week, 2 weeks, 3 weeks later and ratifying it.
Well, you're right. I wouldn't go so far as to say always, because we don't know in every case, what the effect of violating the law might have been. So I think that's an overstatement. I do agree that in some cases the Supreme Court has said that the violation has been cured. There has been no cure in this case. And what we're attempting to do, Your Honor, is to establish a point of law in this case. That you can't use the consent agenda to hide